All right. Good afternoon, everybody. My name is Jeffrey Smith. I'm here with the Orlando Law Group, and today we're going to talk about VA and Social Security disability. Get out your papers, pens, and notes, and get ready to get down some good information. What I'm going to do is I'm going to start it with a general overview, distinguishing the two. VA disability and Social Security disability are obviously both disability claims, but they have very different factors, what you have to prove in order to be successful in your claim. To begin with, and I have my notes right next to me, so if you see me glancing, this is a very broad topic since they are so different. I do have some notes down. So in the VA, when you're doing a VA disability claim, it's important to understand that your medical claims are condition specific. So for example, the VA rates individuals in 10% increments. So you could have a 10, 20, 30% disability for your knee, a 10, 20, 30 or more for a shoulder. And those increments, they, like I said, they come in 10%. It's condition specific. And that's important to keep in mind if you ever decide to appeal or dispute one of the VA's findings. If you think they find you not disabled, or if you think you should have a higher rating disability, higher disability rating, you need to specifically address the particular injury or condition that you're challenging. As compared to Social Security disability, it's binary. You're disabled or you're not. It's 100% or nothing. That's how that works. So in the Social Security world, you have 5 steps to satisfy. In the VA world, you have 4. And this is very general information. Understand what we're going to be talking about today. There is much more detail, but I'm not going to get into that right now because everyone's claim is so very specific and factually related to their particular issues and conditions. So if you're watching this, if you're taking notes, understand this is a very general, more of an informational seminar or webinar as you take it to help you through your claim. And I would suggest if you want to get into more detail, certainly reach out to us. I'm happy to speak with you. And let's get underway. So I'm going to start out, let's start out with Social Security disability. First, are you eligible? That's the first determination that we have to make in Social Security disability claims is even if you do have a bona fide disability, are you eligible to begin with? So there's a few terms we're going to be tossing around in this instance. One of them is going to be SGA. That is substantial gainful activity. And the substantial gainful activity changes every year. And probably the simplest way to state it is it's the amount of money you can earn per month without losing your disability benefits or being disqualified from receiving them. Currently, in 2020, the monthly SGA is $1,260. If you make $1,260 and 1 penny, you will not qualify for Social Security disability. And if you make that amount of money after you're receiving Social Security disability, you stand a potential for losing your entitlement for that particular month. The next we're going to talk about is your date last insured. So essentially, the date last insured is the easiest terms, generally speaking, the last day you worked plus 5 years. If you go beyond that date, most likely you're not going to qualify for disability, meaning if you make your claim for disability beyond your date of last insured, you're likely not going to qualify. However, though, there are exceptions to everything. And what you would need to do if you're going to make your claim after your date of last insured is you're going to have to prove that your disability occurred prior to your date of last insured or on your date last insured. That oftentimes can be very difficult. Another term you're going to hear very often is your onset date. And essentially your onset date is your date of disability. Clear enough. So when we get into the SGA world, when we go into your, well, actually when you're qualifying, what you're going to do is you're going to file your initial claim. Many initial claims filed by individuals fail simply because they don't follow the process, they don't meet the criteria. And I don't want to say it's necessarily that you don't meet the criteria, it's you haven't presented the evidence to substantiate your claims for that particular criteria. Now, in the Social Security world, there's 5 steps. The first step they're going to look at is your SGA. If you're working and currently working and you're making more than the substantial gainful activity, which right now is $1,260 a month gross, you're not going to qualify. So even if you are disabled, if we come to the SGA, the first step, and you're making over that, we're done. We're not going to go any further. You have to, these steps are not randomly arranged. They're in a particular order, so you do not move to the next step until you qualify for the step before it. So first step, obviously, you know, if you want disability because you can't work, but you're actually working, you're not gonna qualify if you're earning more than the substantial gainful activity for that particular time. Secondly, the second step is, let's say you're not working, you're not making any money. Are you diagnosed with a severe impairment? And these are terms of art here when I'm using the word severe. That significantly limits your ability to work, and that impairment must be expected to last at least a year or result in your death. So what that should trigger in your mind is you need a medical diagnosis of a severe impairment. Now, a lot of doctors that you're going to see, I would recommend trying to see a doctor that's familiar with Social Security disability. Reason being is the terms of art are important. The term severe means something to the judge, and you'll see also when we get to the VA portion, there are certain words and phrases as well that are terms of art, that even if you are disabled, those are specific words that the evaluators and the judges are looking for because they're not doctors. So we have to communicate this information to them somehow in a layman term meaning. All right, so you're not working, you're below the substantial gainful activity, that's awesome. You've gone to the doctor, you've been diagnosed with a severe impairment that limits your ability to gain employment. It's expected to last more than a year or your death. What's our next step? The third step is, does the impairment that you've been diagnosed with meet the Social Security listing criteria? And for you super intellectuals out there, that's found at 20 CFR 404 subpart B, section 1. Look it up. It's pretty easy to read. It's not complicated. It's, you know, what you do is you'll go to that website on the Social Security webpage. You could type that part of the code in. It will give you a general listing of your conditions, such as exoskeletal, maybe I think it's digestive, nervous. It'll give you a list of general descriptions. You click on that, and then it will keep narrowing down to your particular diagnosis. And then you will see in that section what you have to meet for your medical what your medical records have to satisfy. So when we go in front of the judge, we are going to need to present your medical evidence, or actually even in your initial claim, your medical records are going to have to support a finding in 20 CFR 404 for your particular condition. Now, if any of you have been to a Social Security disability hearing before, understand that's an appeals process. Ideally, you want to be successful on your first claim, and understand it's medical records, medical records, medical records. Sure, you can give testimony, you can bring witnesses in. What they're looking for is medical records. Your testimony has to be backed up by the medical records. If it's not medically documented, if you are not diagnosed, save yourself the time and energy. You've got to get it in the record. Tell the doctor what you're attempting to do, and you know, get it documented, because if it's not in the medical records, you're not going to qualify. So let's say you're super awesome. You've been working with one of the attorneys from the Orlando Law Group. You've got all your medical records knocked out. Everything is supported. And now we're going to move on to step 4. What step 4 is called PRW, past relevant work. And what the Social Security Administration is evaluating at this point, and we're using a lot of acronyms and letters, and I'll try to remember to say what they stand for, RFC, residual functioning capacity. What the residual functioning capacity means is your ability to do work, taking into considerations your injuries, conditions, or illness, and the limitations those impose on you. So the judge, the evaluator, whatever stage in the process you're in, is going to look at your medical records, and then it's going to make a determination as to whether you can perform your past relevant work. If you can, we stop there. We're done. You don't qualify. If not, then we move on to step 5. Step 5 is very much broader, more broad. It asks, can you do any other work in the national economy? And that's a tough one to get by. What will happen is actually at the hearing, and actually, depending on where you're at in the process, even if this is an initial claim, your limitations due to your condition or illness must prevent you from performing any work out there. And notice that's a little different from what we talked about with the VA. The VA is not income-based. The VA doesn't care about, well, I want to say they don't care, but it's not premised on your ability to do employment, to work. The VA simply is concerned about, are you disabled? Is it related to the military? We'll get into that in a little bit, but it's a very different qualification process. So if there's any veterans out there, you may very well qualify for Social Security disability, but because you qualify for VA disability does not translate into you're qualified for Social Security disability. So when we get to the hearing stage, you've been denied, you've filled out your initial claim. It's a lot of paperwork. It's a lot of handwritten forms. Most of the clients that I've encountered, their claims have failed for lack of medical evidence. Either the medical evidence is out there and it wasn't provided, or it wasn't developed, meaning the client simply didn't go to the doctor enough, didn't go to the right doctor, and their claim isn't supported in the record. It doesn't mean they don't have that condition. We need to get it in writing from a doctor. So when we're at the hearing, we're going to be presenting this evidence. All of your medical records will be provided to the judge beforehand. There will be a VE, a vocational expert, at the hearing. And that is an individual who supposedly is specialized and is highly educated in placing people in work, dealing with people with disabilities, rehabilitation. And what will happen is I will walk you through some testimony, developing your medical evidence into your words. When we get to the end, the judge will then state a certain number of your limitations to the vocational expert. The vocational expert is going to be typing in these limitations into her computer or his, and it's going to spit out jobs. And our goal is to, number one, ensure the judge puts correct limitations as to the VE. And also, if the VE continuously comes up with jobs, we want to make sure the judge included all of your limitations. So when the judge is done with what they call hypotheticals, imposing limitations on you, someone with your age, education, work experience, she may say something like to the effect that you're limited to lifting 10 pounds, you cannot stand more than an hour and a half a day, you must take frequent breaks every 15 minutes. Those are some sort of limitations that they would add to the VE. Now, my job as the attorney is to hopefully get it down to 0, so there are no jobs in the national economy that you can do. However, understand the jobs that we're talking about, some of them that come back are potato chip sorter, worm sorter, bobbin spindle replacer, ticket taker, one of the tough ones to get around is what is it? Security systems monitor. So one of the things I tell my clients before we go into the hearing and what we discuss, actually, you know, we talk about this in the beginning of your case when you first come in, is some things clients do that actually hurt their case. I call them slip-ups. And understand this involves longevity. So if you're seeing a doctor for years and years, the judge is going to give more weight to that doctor's medical opinion than a doctor you've been seeing for maybe 30 days or 2 months. Where clients tend to shoot themselves in the foot with their disability claims, they don't go to their appointments, they cancel their appointments, they consistently reschedule their appointments. If you're not complying with treatment, again, that translates to the judge, you know, this condition really isn't bothering you that much. And oftentimes, you know, you don't even realize you're doing it. And it doesn't mean that sometimes your appointment may need to be canceled or may need to be scheduled, but you need to be aware it's absolutely being documented. And what happens is when the attorney gets all of your medical records that have been going back for 2, 3, 4 years, we can see on there every single month and every single week that you canceled, changed, rescheduled, or just didn't show up for one of your appointments. And it's really difficult, you know, to battle against that. Why aren't you going to your appointments if you're so, you know, have such a disability? The other top place where clients tend to shoot themselves in the foot is they stop taking their pain medications. Overwhelmingly, one of the consistent symptoms in our claims that we get is pain. You know, the client will be like, I hurt too much. I can't get out of bed. I can't do this work. I can't wash dishes, your back, your shoulders, your arms. Well, where we encounter difficulty in that scenario is when we have clients that if you make those claims, but you're not getting any refills on your pain meds, you've stopped taking your pain medications on your own, and you haven't gone to get any more. You're not seeking alternative pain remedies. People that are in serious pain day in, day out, you will notice they will do almost anything to alleviate that pain. And they will go back to the doctor 3, 4, 5 times a month if they need to, if the medication that the doctor's giving them isn't working. One of the clues into the pain isn't that bad is the patient doesn't feel like going back to the doctor to readjust their pain medications, so they just stop taking it. That kind of, you know, makes it hard to promote your pain claim. Another one is not, I think I mentioned not getting your refills. Let's go. Next is the judge may ask you questions. Okay. The judge is not going to ask you any question for no reason. Oftentimes, it may be just conversational. It may seem insignificant, but what they're testing you for is your truthfulness. So, for example, the judge may ask you, have you ever smoked? And you may not have smoked for the past 15 years. And you answer to the judge, no, I don't smoke. Well, if it was in your record many, many years ago that you did, that may be one of the areas where the judge is trying to test your truthfulness in how you're going to answer. So what my advice there is certainly never lie. If you don't know, don't guess. It's okay to say you don't recall at this time, but understand when the judge is conversing with you, you want to pay particular attention to make sure everything that you're responding with is accurate and truthful to the best of your knowledge. Don't exaggerate. Don't, you know, if you don't use a walker for the majority of the time when you're out, don't come into the hearing room with one. On the flip side, don't play the hero. You know, if you are somebody that uses a walker or a cane and you have trouble walking around, you know, don't come into the hearing, you know, sucking up that pain for that day, trying to be a hero. Just be as you are in normal life. And then the end of the hearing, the way it works out is it takes about, on average, about 60 to 90 days to get an order, and we see if you're approved or not. So that's how Social Security generally in an overall view works out. Just a few other tidbits into Social Security. I wanted to touch on, let's see, what did I want? A little bit on COVID, because I know we're all concerned about the virus and our payments. From what I've researched, everything should still be being paid. You should be getting your checks as they're normally delivered. The Social Security offices are, for the most part, shut down for in-person communication. We are still doing hearings. I have one scheduled next week or the week after, I believe, but it's going to be by video. We can do it that way. If you insist on person-to-person, I would say probably the worst case scenario for you is just expect it to be put off and rescheduled. Now, on to VA. One of the things with VA disability, the very first thing you want to do as a veteran is get a copy of what is called your C file, your claims file. Your claims file, you can get that from your regional office. And what it is it is supposed to be, or actually it is, all of the medical records that the VA, the decision officer is going to be looking at to evaluate your claim. It's very, very, very important that you, as the claimant, know what records are in your C file, because that's all they're looking at. And if you don't make sure that your medical records are updated and full and complete and in that C file, that's where the majority of claims are lost, is because you don't know what's in there, and the VA is only looking at the C file. And so that's the first step you want to do. Get it started early, get your C file, go through your C file, and make sure the medical records that you have substantiating your claim are located in there. Now, when you get a C file, very often, especially, well, even if it's in electronic form or hard copy, from my experience, it's going to be a jumbled mess. It's going to look like it came from a Las Vegas, card dealer, shuffled everything all together. The pages are going to be out of order. There's going to be duplicates. There's going to be triplicates. There's going to be quadruplicates of your records. So what I suggest when you get this menagerie is the first thing you do when you open your C file is number each page in the order that you received it, because that should be the order that the decision review officer is looking at it in as well. And it will make it very simple for you to reference a particular page to the decision review officer at the same time while to make sure you're all looking at the same page. Secondly, after you get everything numbered in order as you received it, you want to separate all of the pages for medical records that are pertinent to your particular claim. Because remember, we spoke earlier, VA claims are condition specific. So while you may be a veteran that has 3, 4, 5 or more conditions, you may only be contesting 1 or 2, or you may be seeking to establish a claim for just 1 or 2 of your conditions. So what you want to do at that point is separate all of those records out. You have them numbered, you're going to keep them in order. That's not going to be a problem. Separate your records out, and then you can look and see what your record supports, what the VA is looking at, and it should be fairly clear as to what you need to add to it, what records you need to provide to the VA to fully develop your claim. So when we're talking about VA claims, if you recall, Social Security, we had the 5 steps. Well, for a VA claim, we have the 4 pillars. So the first pillar is pretty easy. Are you a veteran? No brainer. You're going to substantiate that with your DD-214. Remember, there are exceptions to everything. So for the very minority few of you that are veterans, it is possible that some of you will not qualify for a variety of reasons. Some of them, and certainly not limited to these, but dishonorable discharge, what are a few, bad conduct discharge, if the injury occurred while you were absent without leave, generally those injuries are not compensatable for VA disability. Fortunately, that's the minority. Almost all of the veterans I've worked with, none of them fall into that category. So that's pretty easy. DD 214, here you go. You've got your honorable discharge. You're past step one. Step two, you have to establish a service connection. So pretty much what that means is it has to be an event that occurred while you were on active duty, and it has to be documented. So for example, it's not enough that you hurt your knee on a run or you hurt your back lifting artillery shells. That's service connected, but you've got to have an injury relating from that. So you need to have medical records from that time, from that injury, substantiating what occurred, you were injured, with all the medical documentation, to follow through with that injury. So I know I have a lot of veterans, that I've spoken to where, yeah, they were injured, but, we're tough guys in the military, and, Motrin and water, that's all we're going to need. They never go to the doctor, and they never get it looked at. And there's no medical records backing it up. Again, it doesn't mean that claim is impossible to develop, but it does mean it's going to be much more difficult for you to do. Now, additionally, what you'll need to do once you have the service connection is you've got to form a nexus. A nexus means the condition that you're diagnosed with now, and that's something I want to touch on as an aside. You have to be actually diagnosed with a disability right now. I know there are some preconditions. There's a pre-diabetes, I believe, are out there. That's not going to cut it on your claim. You need to actually have a diagnosed disability condition right now that is service connected to as a qualified veteran to have a successful claim. So what we're looking for in that instance is, suppose you did hurt your back lifting artillery shells, and you did go to the hospital and you did receive medical treatment, and here you are, you're 20, 30 years later, you're 50, 60 years old, and your back is starting to add up, the condition has continuously gotten worse. That's a service connection injury there. That we're looking for. It's going to be supported by an event that occurred while you were in the military that was medically documented, and it's now worsened or has become a problem for you now at this point. And you have a diagnosed injury for that. So you're also gonna need medical records recent saying this has gotten worse, this condition has shown itself now. So you need to have that diagnosis right now as well. So the fourth step, once you do all that, is your effective date. And that's what we touch on a little bit in Social Security disability as well, with your date of last insured. Is here in the VA world, it's called your effective date. For most of you, it's going to be the date you file your claim. And what that means is, because these VA claims, and oftentimes the Social Security process as well, takes some time. It's going to take 12, 18 months, maybe more, depending on the particular course your claim takes, and depending on how well supported and developed, and how much work you put into your claim from the onset. So there is one little caveat to that, an exception. And that's for those of you that file a claim for VA disability within 1 year of your date of discharge. There are many, many benefits to that. One of it being you overcome the presumption, meaning if you file your claim within a year of your discharge, it's presumed that this is a service-connected injury. So you've already knocked out half of the pillars that you have to prove. Additionally, when you file your claim for VA disability within a year of your date of discharge, your effective date is not the date you filed your claim, it's actually backdated to your date of discharge. So you get a few more months in there for that claim. Now, when you do these claims, you're going to file your initial claim. The best advice I can give to veterans and Social Security alike is try to make the first time your last time. Support it, get your medical evidence in there, talk to your doctor. I know it's time consuming. I know it's a pain to get appointments, but if you don't do it, you're going to be put in that hamster wheel, and it's going to take you even longer to go back and do it because you're waiting 3 months to 6 months for the VA to render its decisions on some of your claims. So if it gets denied, now you're pushed right back to day one, to go back and develop the medical evidence that should have been in there in the first place. Or of course, appeal for some other reason. When you receive a rating letter from the VA, it's going to state exactly what you're rated for, at what percentage, and for what specific condition. Note that if you're going to challenge that letter, you have 1 year from the date of that letter to file your appeal. Now, understand the appeal process has changed pretty dramatically in the past year. So essentially, for VA decisions that are given after February 19th of 2019, there's a little bit different process that you can go through. You're going to have 3 options, all right? Within a year, you can file a supplemental claim. And a supplemental claim is exactly what it sounds like. You're supplementing your record, meaning you've filed your initial claim, you've waited your time, you've got that decision letter, and you're either not happy with the percentage or you've been denied outright and you disagree with that decision. So if you provide additional medical information that the VA does not have at that time, you're going to follow the supplemental claim process. You're supplementing the record with new evidence that the VA does not have and did not have at the time it made your decision. Now, there's another process called higher review. My recommendation for a higher review, number one, you're not allowed to submit additional evidence for a higher review. A higher review is, in my opinion, most appropriate when your position is that the VA made their decision but did not apply the appropriate law or facts, didn't apply the law or facts appropriately. The decision officer made a mistake of law or fact, and you're disputing that decision based on the existing medical evidence. So if that's your position, and understand sometimes maybe you can have both. You'll want to go with the one that's strongest, but you want to do one at a time. So if your supplemental claim fails and you put in more evidence, that doesn't mean you're barred from doing a higher review. You can always do that. And lastly, if your supplemental and your higher review are still denied, you can do what's called a board appeal. And that is your what you would think of as what was the old VA appeal process, where you file your notice of disagreement, and at this point, I would probably recommend you engage an attorney to get involved, read your evidence, and you're going to draft an actual appeal to the Board of Veteran Affairs. So as far as that, then, again, understand this was a very, very general overview of the Social Security disability claims process and the VA disability claims process. Every claim is unique and specific to the individual. Some of what I stated might apply to some of you, some of it may not. What I recommend is if you're going to start your claim on your own, certainly, try and take the advice I've given, gather all of your medical evidence. You're going to have to do some reading, follow the processes very specifically and exactly. But I can't harp enough on medical record support. That is the number one factor that's going to get your claim approved. It's also the number one factor that gets many claims denied, because the medical evidence provided either doesn't support what you're asserting, or the medical evidence isn't there at all. That's the overwhelming majority of VA disability veterans and Social Security disability people and veterans. You can have both. That's why their claims fail the majority of the time, in my experience. Otherwise, veterans, certainly there's a a county VSO, Veteran Service Officer. Every county in the state of Florida should have one. You can go to the VFW. Of course, you can always contact me. I'm happy to talk with veterans and give them assistance in what to do to develop their initial claim. And then when you're denied, I'm happy to represent you. Same with Social Security disability. Like I said, they're two different animals. We can give general advice on how to develop that claim early on. So hopefully you don't have to come and see us for an appeal. So that's my presentation. I'm Jeff Smith with the Orlando Law Group, 407-512-4394. If you have any further questions, feel free to give us a call. Thank you.